All right, well, good morning, everybody. Almost break time. I think we're going to make it. Good to be here. I'm Mike Linder. You know, for as little planning as we did, this actually follows Mike's presentation pretty well, I think. But before I start, Mike talking about TMDLs, it reminds me back in the heyday of TMDLs when there was a lot of litigation being filed. People were wondering if that acronym meant too many darn lawyers. There were other versions of that acronym too. But so I'm going to talk about the proposed definition of waters of the United States. And this has gotten a lot of press. I'm going to try to take it home to Nebraska and see what it means here. There's a lot of rhetoric, I think, on this proposed definition. So I tried to take a look at it kind of objectively and compare it to what Nebraska does and see where that might take us. And I think it follows Mike's presentation pretty well. So in order to get kind of all in the same place, I think you need to take a look at the Clean Water Act and a little bit of the history and the structure of it. So as Mike said, it was passed in 1972, one of many or several federal environmental statutes that were passed at about the same time. And the Clean Water Act established a comprehensive approach to water quality planning and regulation and permitting. But importantly, it did not regulate water quantity or groundwater. That was always pretty specific. And it also had a principle or an approach of what's called cooperative federalism, where Congress passed a structure, a set of goals, and an oversight role for a federal agency. But for many of the programs in the Clean Water Act, it was up to the states whether or not they wanted to administer and enforce some of the programs in the Act. And so as a result, 40 years later, many of the Clean Water Act programs are administered by states. And that's important, I think, when we're looking at this definition and whether or not it expands that. But so what I'm going to talk about today is just a part of the Act, but it's the two main permitting programs in the Clean Water Act, and talk about kind of how they've taken divergent paths in the last 40 years. Mike mentioned the National Pollutant Discharge Elimination System. That is Section 402 of the Clean Water Act. This is one where many states have taken delegation of the program. It is for anybody, as Mike said, that has a point source that discharges to waters of the United States. So municipalities, industries, others that have an intent or are discharging to waters of the United States have certain limitations they have to follow. And the other program is a Section 404 permitting program, which many of you are familiar with. That's the dredge and fill permit program, wetlands program, called various things. And that is for any dredging or filling of waters of the United States. So, divergent paths. Section 402, I think the count is 45 or 46 states that administer this program and have for many years. So it's become kind of a state-federal program. In order to get delegation, a state has to demonstrate that it has certain program elements that are comparable to the federal program, so a state can competently run a federal or a Clean Water Act program. You have to demonstrate ability to enforce, ability to have adequate staffing to do the program. And so Nebraska sought delegation in the mid-1970s and achieved delegation in 1973, I think. And one of the program elements is to be able to show that you can protect all of the waters that the Federal Clean Water Act would protect. And so many states, including Nebraska, passed its own definition of covered waters, and in Nebraska it is a definition of waters of the state. So any person in Nebraska discharging a pollutant to waters of the state needs to get a permit from DEQ because we run the program in Nebraska. I think there are some 600 outstanding permits, individual permits for municipalities, industries, various type of entities. For individual permits, there's also a general permit program for livestock operations, stormwater permitting, other things, and there are probably in the neighborhood of 2,000 or so entities operating under general permits. And all of those decisions have been made by DEQ using the definition of waters of the state. Now, the definition is found in section 81-1502, paragraph 21. It's a very broad definition, really, and it hasn't been changed much since the early 70s. There was the addition of groundwater, so groundwater is covered by the definition of waters of the state in Nebraska. I think it's one important thing to think about in the Section 402 program is that there really isn't a systemic or widespread recognition around the country that there's a problem with the definitional approach that states have taken, or even EPA in the states that it runs the NPDES program. So Section 404 took a different path since the Clean Water Act passed. As many of you know, that program was retained by the federal government and is administered by the Corps of Engineers and EPA. And I think there are 2 states that took delegation many years ago. Michigan, I know, and I think either New Jersey or Wisconsin. But the reason states didn't take the program is there's no funding. The 402 program, I think Nebraska gets 60% funding for that program. It has to match the other. No funding for the 404 program, and there's no flexibility. That concept of cooperative federalism really wasn't applied to the 404 program. So if you take the 404 program for your state, there's not a lot of advantage because you have to follow prescriptively what the program includes. So those are the 2 main hurdles that states have looked at over the years. So as a result, the Corps has 40 years of kind of an evolving interpretation of waters of the United States. So they've used the federal definition that's in the Clean Water Act. And there have been a number of U.S. Supreme Court cases that have resulted in guidance that the Corps uses to make their determination, field determinations for jurisdictional waters. And compared to Section 402, there are widely recognized problems with the 404 program. It's expensive, it's a lengthy process, there's a lot of inconsistency and difficulty in administering the program, as a lot of you know from experience. And a lot of this is due to kind of a shifting Supreme Court interpretation. And the latest Supreme Court case is the Rapanos case, which laid out this test of a jurisdictional water is a water body that has a significant nexus to a navigable water. So many situations it's fairly obvious, but the Corps has a case-by-case determination as to whether a water body is jurisdictional, and they use their guidance documents to guide them in that process. So because of these kind of recognized problems, EPA and the Corps have tried to fix the problems in the program. And so in April of 2014, EPA and the Corps issued a proposed fix to what was recognized by everybody as problems in the 404 program. And the approach they took was to take that guidance, essentially take the guidance process that the Corps field staff uses and try to codify that into regulations. But their fix, but they knew if they just codified it, they'd have the same problem. So they tried to fix and clarify some elements of the guidance and the process. And in April of 2014, the proposal came out, and the reaction was swift and very critical. Many people felt that EPA and the Corps missed the mark. The clarifications to the amendment would have the net effect of expanding jurisdiction under the Clean Water Act. And really the question is, how much of an expansion would it be? Even EPA in their preamble identified about a 3% increase in jurisdictional waters. Well, a lot of people think it's a lot more than that. And a typical situation of the devil might be in the details and how it gets implemented if it's passed. most of the criticism, if you boil it down, go to some of the newly defined terms, and an approach EPA took in defining the terms, and anything falling within those definitions is categorically jurisdictional, as opposed to a case-by-case determination. So that is kind of the biggest change. So swift and critical, I think 34 states filed negative comments. Many local governments object. Obviously a lot of industry and agriculture and others have objected. Over 1 million comments were filed during the comment period, which is now closed. And EPA is deliberating on those comments as we speak, really. So what I tried to do was look at some of the definitions and try to compare it to what Nebraska has and does. And so one is a comparison to one, and I'll go through them kind of quickly here. But one of the major ones is the definition of tributary. Tributary is used in the CORS process now, but it's not a defined term. And so the proposal would define tributary very broadly and very inclusively, and would basically be 2 banks, a bed, and a high water mark. And if you can identify that feature, even if it's broken by roads or other man-made structures, as long as you can trace that to a navigable water, then it is a water of the United States per se, categorically. And so that's the difference. Some of the marginal waters or questionable waters currently, EPA would make or the Corps would make a case-by-case determination. Now they would be per se jurisdictional. In Nebraska, like I said, the waters of the state definition is broad, probably covers most of these waters, but it doesn't take a per se or a categorical approach. In Nebraska, it's still a case-by-case decision as to whether, in this case, a tributary would be a jurisdictional water. Impacts could be on some of the programs like stormwater permitting, maybe livestock operation permitting, as to whether a facility is having an impact on a tributary, and expanded 404 coverage under the CORS program. One important thing about the tributary definition is there's no element of permanent or even consistent flow, as long as those land characteristics of 2 banks, a bed, and a high water mark are identifiable. It is a tributary, and that's one of the big areas that gets discussed. So the other important definition, or another important definition, is so we have a tributary to a navigable water is jurisdictional, and also any adjacent waters to the tributaries are jurisdictional waters, and adjacent is defined, and the definition includes additional definitions of neighboring. So adjacent waters can be neighboring waters to a tributary, and so neighboring floodplain and riparian areas to tributaries are per se, again, categorically jurisdictional waters of the United States. So this is a change too. The Corps currently has a case-by-case determination on many of these kind of questionable areas. Now it could be categorically waters of the United States. And so, again, the waters of the state definition is broad. It probably covers most of these waters, but it's not categorically part of those a jurisdictional state water. DEQ still makes a case-by-case determination on whether some of those adjacent or nearby waters would be jurisdictional. So now we've got the navigable water, say the Missouri River, a tributary that's identified, and adjoining waters are all jurisdictional per se. How about the waters outside of those areas? Isolated water bodies. The proposed definition takes the approach of calling these other waters, and it still, in this approach, takes a case-by-case determination. So you've got the Missouri River, tributary, adjoining waters, other waters, if they either individually or in a system have a significant nexus to water quality impacts on the navigable water, the Missouri River in this case, they would be jurisdictional waters under the federal approach. But this is still a case-by-case determination by the Corps. They'll still have a case-by-case determination role for other waters. So, you know, this is one of the areas where the critics have said this is a very broad expansion of EPA's current jurisdictional reach. And to me, it's going to depend on how the Corps would roll out this case-by-case determination. And again, Nebraska would still have its broad definition, case-by-case determination. How they would match, you know, it would remain to be seen, I guess. So another big comment area is groundwater. EPA has made, and I mentioned earlier that groundwater is not part of the Clean Water Act program. It's never been a jurisdictional part of the discussion of the Clean Water Act. And EPA, throughout this process, since April of 2014, when the proposal came out, has made a number of comments saying that they don't intend to regulate groundwater, but in the definitions, and I mentioned the definition of adjacent, which includes neighboring and riparian areas, the definition of those terms includes shallow subsurface hydrologic connections to surface water. So do we in Nebraska have any floodplain areas with shallow subsurface hydrologic connections to surface water? I think so. I think we have a lot of them. So that seems to trigger federal jurisdiction. What that means, I really don't know. I don't think EPA really thought that part through. I think that one may have caught them a little bit by surprise, because to me it invokes a federal jurisdiction over groundwater that I really don't know. You know, so do you, in the 402 program, do you issue permits to discharge groundwater in those areas? That to me is a big question mark. So the current status of the proposal, EPA, this administration is winding down its time. And it's got like 3 or 4 things they really want to see get through. One is the Climate Action Plan for carbon regulation. I think they really want to see the ozone regulations pass. The federal waters of the state, waters of the U.S. definition is one of those top 3 or 4 things that this administration wants to see through. So even though they had 1 million comments to read, and I think that's a pretty big stack of paper, they are, my impression or my understanding is they are on the verge of submitting a final rule to the Office of Management and Budget for their review, and then issuance of a final rule, not an additional public comment period, but a final rule that will come out. Now, EPA has stated that they've heard a lot of good corrective things in the 1 million comments they've gotten. So they've hinted certainly that they've made some pretty significant changes to the April 2014 draft. And as recently as Tuesday, I heard the administrator say that she thinks they've got it figured out and they're ready to issue the rule. But it'll be interesting to see how EPA has tried to fix it. Now, Mike's presentation reminded me, you know, I've focused on the permitting programs, but if there is an expansion of waters that are covered by the federal definition, it would follow that, at least in the Nebraska context, beyond the permitting programs, there is the 303 program that lists impaired waters. So does that mean more waters will be included and have to be assessed for impairments and listing on the 303D list? You know, there are a number of areas beyond the permitting program that this could affect. So hopefully EPA, if they do issue a final rule, has made some of these corrections and is something that people can continue to operate under. So are we going to do some questions? That's my comments, and if we have questions. Otherwise, 10:30, that's pretty good, Anthony.
That's not bad. That's not bad. We can take a couple of questions. Anybody? I'm going to get you a mic just so people can hear you. Is that all right?
That's why we wore those running shoes.
Mike, my only question, really, of the million or more comments that were issued regarding the WOTUS, of that, the EPA has said that less than 20 of those were substantive.
And they were all from Nebraska.
Interpret that for me.
Well, I would 20 seems low, but I would imagine there's a very high percentage that are, and I one day went and looked at the docket to see the comments, and there are a lot of form, almost postcard-like things that say, I don't like the rule, please withdraw it. So that is probably a very high percentage of either repeat or form letters, but 20 sound, I haven't seen that number. That seems extremely low. I think, I don't know if it's a good comparison, but in the Keystone process, I remember the Department of State got like 700,000 comments, and I think maybe several hundred were kind of unique, had unique arguments. You know, if you categorized them all, you could come up with a lot more than 20, but yeah, I don't know how to interpret it beyond that.
Oh, that's all right.
Thank you, Mike. That was a great presentation on that. Could you expand maybe a little further what after, so they put out a final rule here. What is the adoption process totally? Does Congress have any say in that, or is it all administrative?
I think there's some activity in Congress on this, either to try to not allow the rule, but it's all separate legislation. It would be issuance of a final rule, and there would be a time period that I don't recall what the, but it wouldn't go back out for public notice is the main thing. Because there just isn't time for this administration to go back through the process of getting comments. Mike? Maybe they haven't thought of it. I don't know. Well, it's an area where there's a lot of rhetoric, and both extremes, I think, are probably incorrect. You know, the EPA has said they're just clarifying, and it'll have a minimal effect. Others have said it, you know, everything, including the mud puddle after the rainstorm in my backyard, is going to be jurisdictional. You know, that's going too far too. But there's definitely it's a different approach.
Some of that, I think, I mean, if the mud puddle in the backyard is jurisdictional after the rule, that's fine. Are you discharging any pollutants into it? And so the next fight would be, what's it mean to discharge pollutants into the Clean Water Act?
Or to fill it. Yeah.
Or to fill it. And that was a question I had, is to what extent is agriculture legitimately concerned about this, or is it driven more by developers and those that want to fill wetlands in order to build houses and roads and things like that?
Well, you know, to the extent there's more area covered by 404, it's more situations you'll have to get a permit. If it's going to the comparison to Section 402 and requiring a discharge permit, that's harder to determine. But the example I think of is the livestock. You know, in Nebraska, DEQ started inspecting livestock operations in 1974-ish. And the test always has been, is there a potential impact to waters of the state? That's the mantra. Those guys go out and, you know, if there's a potential impact, you either have to stop feeding livestock in that manner or build livestock waste control facilities. Well, for 40 years, DEQ inspectors have worked with, especially the smaller operations, to build either diversions around their feeding areas or other landscape features that could be like a series of ditches or you know, and if those very structures that the state has helped operators build to avoid the waters of the state impact become waters of the U.S., to me that would be a really kind of a bad situation, a bad delivery of governmental service, if nothing else.
All right. We kind of do need to head to break. Could you ask him during the break? Oh, okay, go ahead.
My name's Jarecke, and I'm with Caribbean. I'm from broadcaster. I was in Madison, Wisconsin for 6 months, 2 months on the job here as a from broadcast, originally from Illinois. The ag standpoint, it's different state by state because every state has different regulations on water. Livestock-wise, outside of feed, dairy farms have Koley lagoons basically for manure purposes. Thanks. And it's same for hogs as well. Crop-wise, you'll have ditches that run through fields, different things like that. So it has been a big issue and talked a lot about agriculture-wise. Gina McCarthy spoke at the National Farmers Union a couple weeks ago saying that they didn't really think about the impacts of what they were going to say in this waters of the U.S., so they're really re-looking at things and what they really meant to say and how they understand where the agricultural community is coming from. And also in January, the EPA, along with the Army Corps of Engineers, did take back the memorandum for the 404 F1A, and that was the interpretive rule regarding the Clean Water Act section. So they did take that back in January, and because it was a step backwards from what dairy farmer organizations had worked towards in helping with the Clean Water Act, and it was actually going to go back on that.
Good. With that, I think we'll get to break. It's 10:40 now. We'll reconvene about 10:50, 10:55. We've got some time built in because it's just a box lunch. So, thank you. Thank you, Mike.